Hello everyone, welcome back to the video updates. Today's video is going to be pretty short and quick. It's in reference to questions that we receive in different ways regarding the rights of the parties that are named on the deed when the property is about to be sold. So in order to make the video make more sense, I'm going to give some background information on the question that we received this week about this particular topic. The particular property that we're talking about is real estate that was owned by Party A, and then Party A later met Party B and decided to put Party B's name on the deed document. Now, the property itself had a mortgage on it, and the mortgage is in Party A's name, and so Party B was later added to the deed. Remember, the mortgage itself is a promissory note. And that's usually signified by a deed of trust. That's what secures the interest in the collateral, which is the real property itself. And of course, there is also the deed, which is a warranty deed usually, or some sort of deed that has a vendor's lien. There's the actual deed, which is the warranty deed itself, which has the name of the owner of the property, which will really be the document that we look at when we're thinking of title and ownership. And then the second instrument, as I mentioned before, it just tells you who borrowed the money against that property. So Party A in this scenario borrowed the money and then later added Party B to the deed, but not to the loan. So the two names on the title right now are both parties' names. And now they're no longer getting along, and Party B wants to know, what are my rights if the other party wants to sell the property? Do I get a share in the proceeds? What happens? And so my answer is always, it depends, right? Because we have to look to see what was the agreement at the time that Party B was added to the title. So we have to figure out what was the agreement of the parties at the time and how was the addition of Party B's name done. So what I mean by that is, in the deed document that added the second name to the title, what was specified inside that deed document? And was there a side agreement of some sort, like a contract of some sort, that explains why the other person's name was being added to that title? So if there is an agreement on the side that's written, that's going to be what we would look at to determine what are the rights and obligations of the parties. If there is no agreement that was to the side, like a contract or promissory note, then we would look at the deed document alone to see what does it contain, what does it say as to the loan, the underlying loan, or what does it say as to any kind of interest, or is it silent? If the deed document specifies that Party B was supposed to assume some obligation as far as the loan, if the deed document specified that Party B was supposed to assume, some payments as far as the mortgage itself or any mortgage that's attached to the property, then of course that means that Party B may potentially be able to get some proceeds from the sale of that property, but we have to factor in also the payments that Party B was supposed to make towards the mortgage. So there might be offsets, which means credits, or sometimes debits. So if somebody was supposed to assume some portion of the mortgage, in this case, because there are two names, if there is no specificity as to the percentages, we would assume that they're going to go half and half on the debt obligation. So if Party B has paid zero so far, and the property is about to be sold, then Party A could quite fairly argue that Party B owes Party A some certain amount, which will be half of all the mortgage payments that Party A made since the time that the name was added to the title, at the very least, right? So we would look at that, and there's another thing that you could look at if the deed is silent. So the deed might be silent as to whether it was a gift, as to whether it was a purchase, or as to whether there was any kind of agreement for Party B to help towards the full acquisition of that property. So if there is silence there, it will be implied, and rightfully so, it will be implied that party B was supposed to be helping with the mortgage payments, obviously. And that's because if it doesn't say that it was a gift outright, then we must assume that it was the opposite of a gift, which would mean that it was some sort of transaction where there was an understanding of expectation of payment. Now, what type of payment that will be is something that the parties have to fight over. And because there is sometimes equity in law, even when there's the absence of a written, clear-cut, unambiguous agreement, there could be equity there where the courts will look at it and figure out, well, if your name was added to the title and there was a mortgage that was in the background, then it makes sense that you would be responsible for part of that mortgage as well, even though you never signed your name towards the note. So as between the lender and party B, there is no agreement. The party B never signed a note and never signed any kind of deed of trust. So party B is free and clear as to the lender. However, as between party B and party A might have arguments, like I said, asking for offsets, asking for credits for all those mortgage payments. So whether the mortgage payments will look back to the origination of the actual mortgage or look back only to the time that the name was added to the deed, that's something that the lawyers will fight about. If I were representing party A, I would argue that party A has to get credit from the beginning of time, whenever the loan originated. And so party A would get credit for all of those mortgage payments made years and years ago, as well as the mortgage payments made after party B was added to the title. And that's assuming that party B never paid a dime. And of course, that's fair because party A had all that equity in the home, hopefully. And that seems fair because party A likely had a lot of equity in the home before party B was then added on. So it's not fair to then give all of party A's equity to party B or half of it if that was not the intention. Now, if the intention was to give a gift or to give the ownership interest in exchange for love and affection and things like that, the lawyer better have made that clear inside the deed document so that it is 100% clear what's to happen if the property is sold in future. So that's why I said it's important to look at the deed document itself. If the deed document is silent, typically it could be read either way, but of course there's a persuasive argument that party B should be responsible as well for the mortgage payments, taxes, any kind of upkeep with the property. So party A has a chance, so then party A would have a chance to claim credits for all of those expenses. So that's my answer to that. Of course, if I were representing party B, then I would want to make sure that I argue that if there was an agreement at all as to whether party B was supposed to be helping with all those payments, it should have been in writing, because with real estate contracts in most states, all those agreements that are substantive or very important, they need to be in writing. Otherwise, it could be read that they don't exist. So party B could quite frankly get a share of the proceeds from the sale of that property if the document was silent, if the deed document was silent, or if the deed document is ambiguous, because in that case, that means that, let's say the deed document mentioned that there was some exchange of consideration, and then of course the courts or whoever is determining or interpreting that document can fairly say that party B already paid all of the consideration, unless the deed document says that there was some sort of assumption that was supposed to take place. So it's always good for the person drafting the deed, and this is why it's important for you to get a lawyer involved, honestly, because if you're drafting these documents by yourself, you might leave important language out, or you might accidentally leave some language in there that could be detrimental to you and work against you in future. So if you have a lawyer involved, the lawyer would ask all the questions as to what is the intention. Are you giving this person as a gift? What would you like to see happen with the mortgage? Would you like this person to be participating in the mortgage or not? Or would you worry about the equity that's already in the property or any equity accumulated going forward. How is that supposed to be sorted out? So if the person clearly says, look, I'm just putting his or her name on there because I love this person, I don't expect anything, then of course the lawyer does not have to say anything about assuming the loan. The lawyer does not have to say anything about assuming the loan. The lawyer doesn't have to say anything about both parties being responsible for property taxes and insurance premiums and things like that. So be clear when you're trying to do these things, and also if you're not sure, ask a lot of questions and the document will be drafted the right way. So whenever the property is sold, when we start arguing about offsets, when lawyers start arguing about these things, we'll look at the origination of the loan itself, the mortgage that's attached to that collateral, and we figure out who put down the down payment. We'll figure out how much equity was already in the property at the time that the second party was added to the title, and how much equity is there now. And of course, equity is just the difference between the loan balance right now and the value of the property, the market value of the property, or the sale price, if you have a sale price, if you have an actual contract. So that's what the equity is. And the equity would change if you did a refinance and you did a cash out. All those things would affect what kind of equity is there now, as opposed to what kind of equity was there at the time that the second party was added. That's why we have different set points, as you'll say, because the set point when the equity was already there, we'll have to figure out how much was there at the time, and then what transactions took place after party B was added, what contributions did party B make, if any at all. So those are the things that we'll consider, and then we'll be able to give offsets to party A because it seems like it's a fair outcome. Of course, party B could fight really hard and try to drag it out. So eventually people might end up settling, but that's pretty much how you would think about these things. And if you want to be sure that somebody gives you a gift, remember there's a way that it has to be drafted so that you are not responsible for the loan. You are just on the title, and you will get a chance to split the equity without being responsible for the debt obligation. So that's my quick video for you for today. If this has been helpful to you, please give us a like. And as always, thanks for watching. If you like the channel, remember to subscribe if you haven't already done so, and hit that bell button so that you continue to receive notifications of our future videos. Thanks, and have a great weekend.